let me get right into it. I'm so pleased to be able to introduce you to our community, although you've been a longtime member of CPR.
Okay.
So I wanted to begin by talking a little bit about your being selected as outstanding trial attorney with exemplary ethics in 2007. And I was wondering if you could talk a little bit about how your training in dispute resolution, in your view, contributed to that honor.
Well, I believe that one of the major factors that contributed to that for my dispute resolution training was my ability to deal early with opposing counsel and to be able to center in for both sides on what was the most significant interest of the respective parties, to remove a lot of the adversarial aspects and try to focus in on what can we do, even if we're in court and we're going to go to trial, to try to do the best for our respective parties. What are the goals of our respective parties, and how can we make a presentation in court that perhaps doesn't hurt any more than it necessarily has to the feelings of one of the parties to the other, to see if, despite our fighting it out in court between the parties, that the relationship is not going to be hurt. And I think that kind of attitude impressed the courts, impressed opposing counsel, and I was very, very happy to be selected from 70,000 attorneys in Texas to receive that annual award.
I mean, it sounds as if even as a zealous advocate, you've always approached your cases with sort of the mindset of a problem solver, and that was actually valued when the folks who were selecting for outstanding advocate, that those were qualities they were recognizing and looking for.
Yes, and I think it also helped, in fairness to my clients, in my being able to successfully get good results at trials.
Right.
So much time can be spent in fighting over discovery issues, fighting over proceedings, particular rules that apply, that gets us away from what we're trying to do. And I think that that approach helped in communicating to the courts, and particularly in communicating to the juries.
So interesting. So you've had such a wide and varied career as a journalist, a trade union official, working, of course, as an advocate for so many years. Can you talk a little bit about how those experiences contributed to the development of your skills in mediation?
Well, as a journalist, I was essentially a general assignment reporter for newspapers and covering a wide variety of situations. And this necessarily led me to become acquainted with industries, with commercial enterprises, and with the different attitudes that people might have with respect to their employment, with respect to political issues. And from having that journalism experience, I was appointed to be the Deputy General Counsel for the Western Hemisphere Regional Branch of the Worldwide Trade Union Organization. And of course, that dealt having to deal with NGOs, having to deal with trade union officials, having to do a lot of investigation as to particular problems that were encountered. And obviously that directly related later on to work not only as an advocate, but also as a dispute resolution professional.
So as a mediator, you see so many different styles as people come into the room and are representing clients, what are the mistakes that you see advocates make in mediation? If you could sit them down here and say, like, next time, do it a little bit differently, what would you say?
Well, I think one of the problems that we have encountered is right at the beginning with the way that mediators are trained. In Texas, mediators are required to take a 30-hour course on mediation. In my experience, both as having taken that course and being aware of the way it has been proceeding, is that the course focuses on the technical aspects, we can say that, or just the way that a mediation develops. We're trained to say, well, you get together with the parties, you might or might not have a joint conference, and then you shuttle back and forth between the parties, trying to get them to come to an agreement. Well, my problem with that as a mediator, and even before then as an advocate, is that a mediation conference begins right at the beginning with an adversarial approach. Still, after many years of mediation practice, many mediators open the conference with a question to respective parties. What is it that you're demanding? So right from the start, you have this adversarial approach. And I think the biggest correction that I would think, and the biggest error that we might make as a mediator, is not to do adequate preparation. I make it a practice to have fairly detailed conferences with the respective parties before mediation conference. And as an advocate, I was very disappointed that many times I would spend some time preparing a summary of the situation from my client's perspective. And when I got to the mediation, I would discover that the mediator might have or might not have read it. And if it had been read, it might have been read just a few minutes before the mediation conference. So again, the focus of the mediator is, well, what is it that these parties want, and how can we get them to come closer together? There is a terrific loss in ignoring, if we can say that, the respective interests of the parties. And I think it's a basic precept in negotiations, and it should be in mediation, that you do not focus on demands, you focus on the respective interests, because a situation or a dispute may be difficult to achieve if all you're talking about is the respective adversarial demands of the parties, without really taking considerations of what led to the dispute, what does each party have as a stake in the dispute, what is the real solution that each respective party wants or needs, and then work from that approach. And I think when a mediator does that and is well prepared, it not only helps the conference move a lot faster, saves times for everybody, but increases exponentially the chances that there's going to be a resolution.
So from your vantage point, the mediators that you're seeing are just too focused on what's the number here, can we chip away, and can they meet in the middle, as opposed to how did this situation develop, what are the underlying needs and interests, and how can we sort of creatively move forward in a way that those underlying interests are best met.
Sure. As an advocate, I had a situation with a professor at a university who was concerned primarily with a number of issues having to deal with his position, his ability to select courses and develop them. And a dispute arose, and when we got to the mediation conference, the first thing that the mediator says again is, okay, how much money do you want? And I said, look, it's not about money. We have other things that we want to address. And the mediator, to my surprise, insisted, and he would not move from the idea that in order to move along with the mediation, we have to have a number. And after 2 or 3 hours, he finally comes back and says, well, I really have thought about this a little bit, and I now agree with you, and I think that we're going to have to address, the interest of your client. And by that time, my client was so distressed, so upset that he just did not want to proceed. And we ended up at an impasse, within 2 or 3 hours of the beginning of the mediation when, we could have made some significant progress.
Right. So you're seeing some of the potential of the process not being captured because of a mediator sort of misfocusing on really, numbers as opposed to underlying interests.
Yes, and again, I think it goes back to the basic training that has developed for mediators. And the training, totally does not address what should be the real goal of the mediator. It does not address basic principles of negotiation. As a mediator, you're really working as an assistant negotiator for both sides. It does not focus on things that could be very helpful. Nonverbal language, signs that one of the parties might be giving that can give you some real idea as to the seriousness and the accuracy of what you're being told. 30 hours or so probably is not enough really to make a good mediator. And it really is even worse when the training focuses on, well, how are you going to run the mediation rather than what is the purpose and how should you really go about it?
Right. It sounds like 30 hours is too short and they're focusing on the wrong things. Sounds like you need to spend some time with the curriculum committee at the Texas bar. Maybe start counseling them.
I just gave a presentation for the dispute resolution section of the local bar, precisely focusing on that. And we're going to have a meeting. And one of the things that I want to address, they have elected me to their council. I'm going to try to say, hey, we need to address this training issues. We really do, because otherwise the appreciation and the willingness of parties to engage in mediation is going to continue diminishing.
I'm glad to hear you're focusing on this. It sounds like a problem that needs to be addressed. You have traveled, you've lectured, you've taught all over the world, and you've mediated cross-cultural disputes. And I'm curious if you could talk a little bit about what makes a cross-cultural dispute different from disputes where all of the participants are from the same culture, and what would you do differently as a mediator in those cases?
Well, we should know, and I think if we really look at it carefully, we know that individuals from different cultures deal differently with one another, deal differently with their willingness to discuss disputes. And unless there is some sensitivity to that, it can be really problematical, and you may end up hurting the chances of a resolution of a dispute rather than helping. And it is a complex area, and one that really needs to be developed for those of us who are doing cross-cultural dispute resolution. For example, if we look at it from the standpoint, well, you have to know that individuals from Latin American countries have a different approach. They need to spend more time becoming familiar with one another, becoming familiar with the mediator. But you have to look at it carefully, because it might be that these parties, or one of the parties from the mediation, is looking from the standpoint of saying, well, here we have a mediation. It's being set up from the United States, is being set up in accordance with the administrative institution from the United States. We have to change the way we approach it from the way we normally would to adapt to this Anglo-American approach that we're going to have. So, you can have the respective parties looking at one another and looking for change, and really become more confused rather than helping, unless you really take the time to understand and to realize, how far can you go? If you are making assumptions, for example, on a mediation or an arbitration with a party from Latin America, it might be that when you're trying to approach it in a sense of being more friendly, asking about the advocates, families, their approach and so forth, that the other side might be reading you as stereotyping, and saying, well, here comes this gringo and he's trying to tell us how we should be doing things, and we're really going to show him that he really doesn't know very much about us. So even when you're trying to adapt to the culture, you have to be very, very careful that you're doing it in such a way that's going to be productive, not negative.
Right, right. Do you meet with the parties and their advocates before the actual mediation to kind of suss out what their expectations are of you and of the process?
I think that's essential, and I think that it's a big mistake not to do that. I insist on meeting with the parties individually, not at the same time, well before the mediation, to really explore not only the issues on dispute, not only the rules or laws that might apply, but more than that, again, trying to see really what is behind this dispute, what is causing it, and what are the respective parties of each of the parties. Then it makes it easier then if you start the mediation with a joint session and address some of the things that you have discovered in your meetings. And I am surprised and somewhat disappointed. I'm certainly of an opposite conclusion about eliminating the joint conference as the start of the mediation. I think it's very, very helpful to do that. Even in the occasion when the parties hate each other, when you feel that they're going to be on the verge or even actually jumping through the fence of being insulting to the other side, you need to get that out of the way if it exists, and avoid it if you can.
Do you, when you're meeting independently with the parties and counsel, or maybe, I don't know if you ever meet separately with counsel, do you ever counsel them on, look, we're going to be all together, this is not your peroration to the jury, this is not your opportunity to grandstand in front of your client. Remember, we're not going to reach a resolution unless the other side agrees. So alienating them, first off, is not going to be productive. I mean, do you ever find yourself?
Yes, of course. That's one of the things that I try to do when I meet with the parties. But at the same time, recognizing that it is the mediation or the arbitration of the parties, and that they're actually hiring me, and they're not hiring me to lecture them as to how they're supposed to do the job. My approach is to tell them, look, here's the way that I see that the mediation should process. Here is the things that I have observed that are positive. Here are some of the things that I have observed that are negative. And what do you think about it? And let them bring it out and see, and then not in the sense trying to change their mind, but helping both sides, helping them and helping me adapt to the circumstances of that they're presenting.
Very Mediator-like. What do you think about these observations as opposed to lecturing? Yes, that sounds much more productive. So my final question for you, do you have a favorite mediation when you think back on all the mediations you've done? Is there anything that sort of sticks in your mind?
Well, I don't think to preserve memories of mediations. I think that, that it's wise not to keep a lot of details in your memory, because you might expose or bring the confidentiality without intent. But I can speak generally as to those mediations that I have really enjoyed, and those are the ones where the parties break up the conference by shaking hands, by expressing, good feelings, sometimes by even embraces of saying, hey, I'm glad that we got this over with and let's work together from now on. Those are the kinds of things that make me happy and that I would like to think back on.
That's great. That's wonderful. Mr. Lopez, thank you so much for your time. I really appreciate it. I know that our audience is going to enjoy listening to you, and I know we also have additional work projects, so I'm looking forward to future engagements.
Thank you very much. I enjoyed it.